So first, we have Professor Dale Goble, who is the Shimke Distinguished Professor at the University of Idaho College of Law, who will enlighten us on understanding wildlife law. Professor Goble.
So is this on now? Okay. So I'm going to talk about the framework, the skeleton, if you will, of wildlife conservation law in the United States. I have to get this going. It's something of a Rube Goldberg construction. Okay? It's sort of composed of some common law principles, some bits of con law, and a handful of statutes. When I put this in, that was the only metaphor I had for this, but it's become doubly applicable after all of the people that have gone before me, most of whom I'm going to repeat in some way or another. So hopefully I will take some of those themes and facts and points and sort of stir them into a new mix that will provide a useful framework for understanding how wildlife law works. The framework is the result of an interaction of two different and independently evolving types of knowledge. The first is the shifting understanding of what self-government means. In the United States, one of the primary political contexts through which our ideas of self-government are worked out is federalism. This is particularly true when something affects more than one state and wildlife tend to ignore boundaries. Since federalism is a political system, it's continuously responding to Tip O'Neill's first rule of politics. The second body of law, or knowledge, if you will, is our understanding of what wild animals require to make a living. This body of knowledge is created by the process that we call science. Its current sort of position can be summed up fairly simplistically by Barry Commoner's first rule of ecology. We live in an interesting time when the answers that science currently provides are rather unpopular and are often ignored as a basis for decision making. Two additional introductory points. First, there's an obvious tension between a political system that ultimately is focused on the local and nature, which is both mobile and more than local. Second, since both our political system and our understanding of the relevant science have changed over time, the current framework for wildlife conservation is an historical artifact. Understanding the current framework thus begins with something of a historical perspective. Now, the history of both law and the science of wildlife is rather old, at least 2 millennia old at this point. I only have 20 minutes before I have to give way to Holly, so this is going to be the Reader's Digest condensed version. Legally, what are animals? Okay, what is the status of a wild animal? In the Western legal tradition, wild animals, that is, animals feri naturae, were initially classified as res nullius, things that don't belong to anyone. This meant, of course, that they belonged to the first person that captured them. It's the story of Pearson Post and the fox from every law school's first-year property class. It was Roman law that classified wild animals as things that belonged to no one. England and the common law began to diverge from their Roman roots when William the Bastard crossed the English Channel, killed good King Harold at the Battle of Hastings, and changed his name to the Conqueror. He and his successors claimed the power to control wildlife. In the medieval feudal society, such claims were stated in the language of property. The king's assertion was that he owned all of the wild animals in his kingdom. The king claimed not only that he had the power to decide who could hunt animals, but also that he had the power to conserve deer and other wild animals by controlling their habitat. The king had the power to designate large tracts of land as forests and to prohibit any use of those lands that reduced the quality of the wildlife habitat. The king's claim to the ownership was accepted by the common law courts in a series of judicial decisions that began with the case of swans, decided at the end of the 16th century when the king was actually Queen Elizabeth. Now, it helps to understand the importance of the case by recognizing that swans were the turkeys of the 16th century. No self-respecting feast could occur without a dozen or so swans, and so who controlled swans was actually sort of an important event. More importantly, though, than the case of swans, for the development of the law in the United States at least, was that the king's ownership of wildlife was endorsed by William Blackstone. Although the state of the law was far more ambiguous than Blackstone acknowledged, his commentaries on the common law was, for most courts in the United States at that period of time, the common law. The courts did not have case reporters from England. And one of the anecdotes that's repeatedly told about Blackstone's commentaries is you could put both of them into the saddlebags of your horse, and that the judge, that when you were the lawyer following the judge on judicial circuit, that would be the law book that you would bring with you. Blackstone's description of the king's property and wild animals raised a fundamental question. What does it mean that the king owned the wildlife by his prerogative? The king is both a man and a sovereign, a human and a government. Obviously, the king as a man dies, but the king as sovereign doesn't die. Okay? How did the king own the wildlife? Did he own it as the man that dies or as the man that doesn't die, the government? Over time, well, okay. In William the Conqueror's time, that question was nonsense. Okay? The world was not understood as a division between property and sovereignty. The king had these rights, he doled them out among his best friends, okay? And so the distinction between sovereignty and property was meaningless at that point. Over time, however, the distinction between property or personality and sovereignty, the question of whether the king owned the wildlife as a person or as the king, became important. It became particularly important if you have a revolution to get rid of the king. What happens to the king's stuff? In 1821, the New Jersey Supreme Judicial Court was presented with a case that required it to decide who owned the oysters in Raritan Bay. The issue, or the case, neatly divided the personal and the proprietary. The proprietary, and the sovereign. Okay? The way the case came up, it was either the king owned it as government or the king owned it as a person, and who got it. Okay? The New Jersey court decided that the oysters belonged to the king as a sovereign and not as a person. Okay? So, the people became sovereign in the United States with the Revolution. Therefore, the people owned the oysters in Raritan Bay. How did they own the oysters in Raritan Bay? In common? No. They owned them, but then with the Revolution, they transferred their power, their sovereignty to the states. So the state became the owner of the oysters in Raritan Bay. Well, how did the state own it? The state owned it as trustee for the people. Okay? It's the public trust doctrine. At the time of the Revolution, the people transferred their sovereignty to the state. Subsequently, the people took some of that sovereignty back and gave it to the United States government, okay, in 1787 with the ratification of the Constitution. That's federalism. We now have these two governments that have some of that sovereignty that the king had, but that the people took with the revolution. Who now owns the oysters? In a case decided about 20 years after Arnold versus Mundy, the United States Supreme Court, in a case called Martin versus Waddell's lessee, the same question, the court reaches the same conclusion. The states were trustees for the land and the resources beneath navigable waters, and the Commerce Clause did not change that result. The case of Swans, Arnold versus Mundy, and Martin versus Waddell, are the foundation cases for two different lines of legal decisions. The first and the better known of those is the public trust doctrine as applied to the ownership of beds and banks of navigable waters. If you go back and you look at the English cases, the king was also said to own the beds and banks of navigable waters by his prerogative. The second doctrine, though, is the public trust in wildlife, or as it was known, the state ownership doctrine. Okay, over the course of the 19th century, the state courts and the federal courts worked out the divisions of that. They fleshed out the public trust in wildlife and drew the line between the trust that the state held in wildlife and the federal commerce power. That development was capped in a decision by the United States Supreme Court in 1896, Gear versus Connecticut, where the court traced the legal history back to ancient Greece and Rome, and emphasized that the state's interest in wildlife was as a trustee for the people. The central idea of a trust is that the trustee has the responsibility to conserve the property that is held in trust. The trust in wildlife thus gives the state both the power to control access to wildlife and the obligation to conserve the resource. In short, the trust imposes conservation obligations upon the state. As is often the case, Gear was decided at a time of change. Reaffirming the law is seldom more important than when it is being questioned fundamentally. Some of that questioning can be traced to this bird. This is the passenger pigeon. This is John James Audubon's famous painting of the passenger pigeon. And in 1813, the autumn of 1813, Audubon was riding a horse across Kentucky between two places, and a flock of passenger pigeons began to fly over. And he sat down and began figuring out how to count them. Okay? There were more than 1 billion individuals in the flock. Okay? The species was probably the most abundant bird in the world when Audubon recorded his sighting. Okay? It existed in such prodigious numbers that it seemed simply inexhaustible. Pigeons, however, were tasty. They were also the predecessors to today's clay pigeons. Passenger pigeon became commercially extinct in the mid-1880s, became extinct in the wild in the 1890s, and the final specimen died in the Cleveland Zoo a century after Audubon described the flock in Kentucky. And the passenger pigeon was not the only species, or only trust asset that was being rapidly depleted. One result of the confluence of events, okay, and this is something that Peter talked about. This is one of Peter's stages. Okay, this is the progressives, if you will. The confluence of the events that led to the extinction of the passenger pigeon was a creation of a coalition of scientists, Audubon societies, and hunters that feared that the pigeon was only the first of many species doomed to extinction. The coalition focused its conservation efforts on market hunting and the plume trade. Although there had long been a market for game, particularly waterfowl and other game birds, the technological changes after the Civil War provided new opportunities for market hunters. The railroad provided rapid transportation, and the refrigerated car prevented spoilage, and thus opened markets in once distant metropolitan areas. Given the period's understanding of constitutional limits, particularly the relationship between the Commerce Clause and what was called the police power, ending market hunting required an enactment of a statute in every state. Although by 1900, most states had established fish and game agencies, the agencies were, shall we say, frequently weak and ineffective, and enforcement was at best sort of hit and miss. Furthermore, in many states that were crucial to the protection of game birds, there were no wildlife agencies. In 1900, there was not a single wildlife agency in the South. Okay? This is what I have elsewhere called the tragedy of fragmentation. Boundaries, be they political or property, lead to myopia. Why should Missouri limit the numbers of duck that a Missouri hunter can kill when those ducks will be in Arkansas tomorrow or Louisiana the day after? None of those people in Arkansas or Louisiana vote in Missouri. And when not only Missouri, but all of the other states along a flyway took the same political incentive, the result was overharvest and extinction. The conservationists therefore turned to the federal government. The President negotiated a treaty, the Senate ratified it. It's a treaty with Great Britain acting on behalf of Canada in 1916. 1918, Congress enacted the Migratory Bird Treaty Act. 1920, the United States Supreme Court upheld the Migratory Bird Treaty Act in Missouri versus Holland. That case signaled a watershed. The transformation was captured in the phrase from Justice Holmes' decision that the court has repeatedly quoted over the last 80-plus years. To put the claim of the state upon title is to lean upon a slender reed. The Supreme Court's decision in Missouri versus Holland, the decisions since Missouri versus Holland, has brought wildlife law into conformity with the general constitutional principles. Congressional powers such as the Treaty Clause, the Commerce Clause, and the Property Clause apply to wildlife just like any other resource. Constitutional limitations on state powers such as the Dormant Commerce Clause and the Privileges and Immunities Clause that prohibit states from allocating resources to favor their own citizens' commercial activities also apply to wildlife. But, and this is a substantial but, okay, wildlife is not just another resource. Although the court no longer talks about it in terms of state ownership, it has repeatedly noted that that ownership and trust language was simply shorthand for the states of special interest in regulating and preserving wildlife. It is a substantial interest that differs from the state's other interest in resources. Wildlife is, in fact, a unique resource within the federal system of the United States. Okay? Thus, a state special interest in wildlife gives it broad powers to regulate non-commercial access to wildlife, even to the point of being able to discriminate against non-residents. But there is an irony in my story. Not being a historian, I appreciate irony. Okay? So maybe lawyers are just historians with irony. I don't know. Anyway, the most important bit of the federal Constitution when it comes to wildlife in the United States, and particularly wildlife as it's managed by states, is the spending clause. It's never been challenged. Okay? Spending clauses had more impact on state conservation activities and law than anything. The earliest and still most influential example of this federal power was mentioned earlier. Okay? It's the Federal Aid in Wildlife Restoration Act, commonly called the Pittman-Robertson Act. It makes money available to the states to acquire, restore, and manage wildlife habitat. Most state wildlife management areas and refuges have been acquired through funding under the Pittman-Robertson Act. More significantly, however, the Act has promoted the professionalization and reliance upon science by state wildlife agencies. It did so by specifying that states could not receive federal funds if they had not enacted legislation requiring hunting license fees to be used solely to fund state fish and game departments. There are other grants now, okay? I mean, that's the cornerstone of it. It requires the states to plan for wildlife conservation and to acquire habitat for wildlife conservation. And it attempts to professionalize and require science to be the basis for those decisions. There are other similar grant programs. The most significant one right now is the state and tribal wildlife grants program. Somebody earlier talked about that. I don't remember who it was now. As a way of planning for non-game in the face of climate change. Okay? It provides money to the states to map locations of species and to decide how they ought to be managed to be conserved. Perhaps one of the reasons I'm not as optimistic as many of the people that have come before me is that, for example, the State Wildlife Action Plan was zero funded in the House budget that just passed. There are unintended consequences to this kind of a funding program. It's sort of a classic example of he who pays the piper calls the tune. State fish and wildlife agencies are dependent upon hunters and fishers, and they are generally unwilling to take actions that are unpopular with that constituency. This becomes problematic in a period when the sales of hunting licenses are decreasing. The total number of hunting and fishing licenses sold in the United States in 2010 was essentially the same as was sold in 1958, about 14 million hunting and fishing licenses. Now, if the U.S. population had stayed flat in the same period, there'd be no change, right? U.S. population's increased 76%. Okay? Hunters in 1958, or the people that bought hunting or fishing licenses anyway, were 8.1% of the population. They're now less than 4.6% of the population. The risk is this increasing isolation. Okay? To the extent that states' fish and games are dependent upon that single source of funding, there is a real possibility of isolation. So, what is the framework? What is the framework for wildlife management in the United States? Under our federal system, the states have all powers that are not denied to them either by the United States Constitution or their own individual constitution. Given the variety of states, right, this is a really simple slide. This is which states have Endangered Species Acts, and then do they cover only animals or also plants, or do they have a separate one for plants? So, I mean, and the states are literally sort of all over the map. Okay? Given the variety of what states do and don't do and how they are funded and everything, it's impossible to talk about the states in some sense other than aggregates that don't really make a whole lot of sense. Okay? So, congressional action falls into two broad categories. First, Congress has used its constitutional powers to preserve trust assets in a small number of situations in which the states have arguably failed to do so, often because of what I have called the tragedy of fragmentation. Federal powers have been used to conserve migratory birds, marine commercial species, and imperiled species. And this is the one I don't need anymore. Bob took care of this for us, okay? As you know, the United States also owns a significant chunk of land, particularly in the West. You can divide those lands into multiple use lands, where wildlife is sort of one of the resources that's to be considered, sometimes more with the National Forest Service and less with the BLM. And then there are also these dominant use land systems, okay? The National Park System, the National Wildlife Refuge System, on which wildlife is either the dominant use or arguably an element of the dominant use. There's also other categories as well. There's overlay systems, the Wilderness Act and the Wild and Scenic River Act, for example. Those generally have relatively little actual impact on the management of wildlife. The list sounds lengthy, but it applies to a relatively small number of the total number of species that are nominally managed in the United States. And furthermore, in most situations, the states actually share management with the federal government. Migratory waterfowl, for example, are managed by flyway councils, which are composed of federal, state, and provincial representatives. It's that group that actually sets harvest goals and things like that. This is the Pacific Flyway, okay? And it involves the BC, Alberta, and then the states as you work your way down. So, what is the framework? It's the Rube Goldberg contraption, okay? Which makes it pretty much like all of our federal system, it seems to me. Questions?
Sorry. Just one historic note. Lawyers are historians who don't remember the past.
That may be true. That may be true. Or make it up as we go.
I am always interested in how we retrospectively, especially as lawyers, can reconstruct the intellectual genealogy, so to speak. What's your suggestion, if you were czar for a day or so, that you would do to better manage wildlife?
Yeah, thank you. There needs to be more cooperative management. Wildlife tends not to stay still. It tends to move around a lot. It tends to walk across boundaries, whether those boundaries are boundaries between Wyoming and Idaho and Utah, or whether it's boundaries between national forest and BLM land and private land. So what we need to do, it seems to me, is to figure out a way to rationally acknowledge those issues and then to try and sit down and figure out what we do about them. Lawyers always talk about process, don't they? And I think that the solution is a procedural kind of solution. And I'm not sure exactly how to put it together, but I do think that it involves the recognition that these are things that wander around, and the only way we're going to be able to manage them, particularly the way things are going to change when we move forward into global climate change, is to sort of really make some hard decisions about where things are going to be.